Assalamualaikum warahmatullahi wabarakatuh. Good afternoon, ladies and gentlemen. Welcome to the joint class series held by Faculty of Law, Universitas Brawijaya, in collaboration with Faculty of Law, University Kebangsaan Malaysia, UKM. Today, 8 December 2020, the second joint class entitled Federalism and National Legal System. Let me introduce myself. My name is Mega Novita, and today I will be your master of ceremony. We really appreciate everyone involved in this joint class, the honorable distinguished guests and speakers. They are Ibu Dr. Siti Nur Hafizah Azizan from University Kebangsaan Malaysia, Ibu Afifah Kusumadara SHLLM, SJD, Senior Law Lecturer at Universitas Brawijaya, Dr. Nur Hafilah Musa from University Kebangsaan Malaysia, Syahrul Sajidin SHMH, and Priska Listening Room SHLLM from Universitas Brawijaya, and also the chairwoman who will be our moderator today, Ibu Dr. Rika Kurniati SHMA. Thank you very much for sparing your time in your very extremely busy time. And I would also like to thank all participants who has joined today, yesterday, and maybe tomorrow. Thank you very much for always supporting us. Thank you very much for your cooperation. Hopefully this joint class can run smoothly till the end. The Faculty of Law, Universitas Brawijaya, and University Kebangsaan Malaysia have established academic cooperation through several MOUs. The latest MOU was signed in August 2019. This joint class program is one of the academic activities held to implement the MOU and to foster further collaboration between the two institutions. Besides that, this joint class program is expected to broaden the knowledge of the law students in both universities and to enrich them with different legal perspectives, different legal culture, and different legal history. The first joint class series have been held successfully yesterday. Today is the second joint class, and tomorrow will be the final one. Before we start today's joint class, I will explain the rule that needs to be followed by all of the participants here. You are advised to mute your microphone to reduce the background noise, but basically, the host will automatically mute them. We recommend you to turn on your camera because in the end, we will have photo session. Firstly, the speakers will share each of their presentation and then just followed by the Q&A session after finishing the talk. In the Q&A sessions, participants can ask by writing the questions in the chat room, in Zoom, or in YouTube, or ask directly by using the raise hand option, and then our team will unmute you. You can deliver the questions in both English or Bahasa Indonesia, but just keep it simple. After the speakers finish their talk, our team will send a link of attendance form in the chat room. The certificate of participation, auto-generate from this attendance form, will be sent to your email address. So please make sure to write your name and your email address correctly. We also provide YouTube live streaming. Please check the link sent in the chat room. We request your cooperation to focus on the speakers while they give the talk. Everyone, let me brief you the today's program. First is registration and preparation. Second is lectures, which will be led by our moderator, Ibu Rika Kurniati, PhD, and there will be 3 speakers. They are Dr. Nur Hafilah Musa and Shahrul Sajidin SHMH, and also Prisha Listening Room SHLLM from Universitas Brawijaya. Then after the lecture session, we will have photo session and closing. Ladies and gentlemen, we are now about to start to the main agenda, which is the presentation from our great speakers. Our moderator, Ibu Rika Kurniati, PhD, will lead the session. However, before she starts, let me introduce Ibu Rika Kurniati, PhD. She is a lecturer in International Law Department, Faculty of Law, Universitas Brawijaya. She finished her bachelor degree from Universitas Brawijaya, master and doctor's degree from Ritsumeikan University, Japan. She has published many articles in national and international journals. She also actively joins the conference abroad. Ibu Rika Kurniati, PhD, now the time is yours.
Thank you, Bu Mega, for warm introductions. Let me start. Honorable Dr. Siti Nur Afizah Azizan, the Project Coordinator of Faculty of Undang-Undang, University Kebangsaan Malaysia. Honorable Dr. Afifah Kusumadara, the Head Unit of Research Community Service and Cooperations of the Faculty of Law, Brawijaya University. Respectable all speakers, colleague from University Kebangsaan Malaysia, and colleague from Universitas Brawijaya, and honorable students and all participants. Greeting from Brawijaya and welcome to the second day of the joint class program. Assalamualaikum warahmatullahi wabarakatuh. Ladies and gentlemen, I am Rika Kurniati, the moderator of these sessions. The topic for today's joint class is federalism and national legal system, and we are very happy because today we have three great lectures from Faculty of Undang-Undang, University Kebangsaan Malaysia, and also lectures from Faculty of Law, Universitas Brawijaya. The first lecture is Dr. Nur Hafilah Musa. Dr. Nur Hafilah is senior lecturer at University Kebangsaan Malaysia. She obtained a Bachelor in Law from International Islamic University Malaysia, Master of Art from University of Malaya, and she completed his PhD degree from Melbourne University. Dr. Nur Hafilah's specializations or research area is on Malaysia legal system, human rights, Islamic law, and federalism. Today, Dr. Nur Hafilah will deliver a lecture on the topic related to Malaysia federalism's framework and challenge. The second lecture for today's sessions is Ibu Prisca Listening Room SHLLM. Ibu Prisca is a lecturer at Constitutional Department of the Faculty of Law, Universitas Brawijaya. She holds bachelor degree in law from Universitas Brawijaya and Master of Law from the University of Edinburgh, United Kingdom. Ibu Prisca research area or specialization is related to constitutional law, human rights law, local governance, constitutional court procedure law, introduction to Indonesian law, also environmental law. And beside Ibu Prisca, today we have also Mr. Shahrul Sajidin from the Faculty of Law, Universitas Brawijaya. Pak Shahrul is a lecturer at Private Law Department. He obtained bachelor and master degree in law from Universitas Brawijaya. His research topic or specialization is related to economic, labor and employment law, also civil law. In these sessions, Ibu Prisca and Pak Shahrul will deliver a lecture on federalism in Indonesia and Indonesia legal system. Well, ladies and gentlemen, before the presentation begin, let us know the regulations, how the class will be going on. Firstly, the speaker will present their topic for about 30 minutes. So Dr. Nur Hafilah will have 30 minutes to deliver the lectures. Ibu Prisca and Pak Shahrul together also have 30 minutes for the presentations. After the presentation, we will move on to the question and answer sessions. For these Q&A sessions, the participant who wish to ask the questions, please kindly write down your name, your university or institutions, and to whom the question is addressed for in the chat box. I think that's all for the structure of these sessions. Well, before the speaker began, I kindly request the participant to mute the audio, and maybe if you would to turn on your camera, so the lecture will be going well. Well, ladies and gentlemen, without further ado, allow me to welcome the first speaker, Dr. Nurhafila Musra from University Kebangsaan Malaysia. Dr. Nurhafila, the time is yours.
Okay. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh, and a very good afternoon to all, ladies and gentlemen, our beloved students from Indonesia and also from Malaysia, or from whichever part of the world that you are in. I'm very honored to be invited for this session, and thank you to the organizers and the committee for setting for such a good seminar for everyone. So I'm moving on straight to what I'm going to share. So I'll be sharing my screen. Okay, I hope it's clear for everyone. So I will be talking for about 20 to 25 minutes roughly about Malaysian federalism framework and challenges, which is very challenging to talk because we have been using federal system for more than half a century. So what I'm going to share with all of you is actually some snapshots of what Malaysia have been through for the past decades, right? So basically, just a brief summary of the states in Malaysia. Okay, so why do we call Federation of Malaysia? Because we have 13 states and 1 federal territories. As you can see in the map, their flags. Okay, so in our constitution, in the Malaysian constitution, it is stated under Article 1(2) that the states of the Federation of Malaysia shall be Johor, Kedah, Kelantan, Melaka, Negeri Sembilan, Pahang, Pulau Pinang, Perak, Perlis, Sabah, Sarawak, Selangor, and Terengganu. And as you can see, all the flags of the states are there, and you can see 3 extra flags here. So these are the federal territories of Kuala Lumpur, federal territories of Labuan, and Putrajaya. So the combination of all these 3 federal territories and the 13 states create the Federation of Malaysia. Okay, so I'm not going to dwell into the history because it's quite long. Okay, suffice to say that how federation come into being is basically a legacy from the British colonial rule, and that is what we are continuing until now. So before I go into the structure and everything, it's just to recap or just to share with all what are actually the common structural features of federation. So I'm sharing with you what is has been explained by Professor Ronald Watts, a Canadian federal scholar who has passed away. So basically, what is a federation? A federation is actually there must be at least 2 orders of government, each acting directly on their citizens. All right. The second features is there must be a formal constitution, a written constitution, which distributes the legislative and executive authorities and allocate revenue resources between 2 orders of government, ensuring certain degree of autonomy for each order of government. The third one is there must be a provision for the designated representation of distinct regional views within the federal policy-making bodies. As you can see in the Malaysian federal system, which I'm going to explain later, so each of the states have their representation at the lower house and the upper house of the parliament. The fourth features of what is a federation is there must be a supreme written constitution, not unilaterally amendable, and requiring the consent of a significant proportion of the constituent units. It means that the constitution must be hard to amend, okay, and if there are certain amendments that affect the rights of the states, then that amendment must require certain consent from the constituent units. The fourth feature is an umpire or a referee, as you can call, in the form of courts to rule on disputes between governments, either between the federal government and the state governments or between the state government themselves. And the sixth is processes and institutions to facilitate intergovernmental collaboration for those areas where governmental responsibilities are shared or inevitably overlap. It means that when there are two orders of government, two levels of government, therefore, there must be certain areas where there are collaborations, okay, between the levels of governments. So because despite the constitutional division of power, there are certain matters that will overlap. So they need there needs to be certain how do you say, coordination between the parties. Okay, moving on. So I'm just going to how do you say, put the historical context in 2 slides. Okay, so it's a very long history, so I'm just going to put it in 2 slides. Okay, the main trajectory where we got our roots of federal system and then where we are now. So basically pre the year 1896. Okay, so we have a state called Negeri Sembilan, which is originated from Indonesia. Okay, the ruler originated from Indonesia. So Negeri Sembilan actually mean 9 states or 9 regions, okay, where they unite to create a federation. So it's not it's not a federation in the modern sense, but it's how do you say, it's a loose kind of federation where the office of the Yang Tuan Besar Negeri Sembilan was created to unify as a unifying symbol in the regions, okay, in the regional wars against external aggression. So that was Negeri Sembilan, and we have Negeri Sembilan until today. And during the British colonial rule, British came to 4 states in the Peninsular Malaysia, starting with Perak and then Pahang, Selangor and Negeri Sembilan. And later on, when they want to amalgamate the administration of the 4 states, so they created a so-called federation. So, and all the Sultan or the Malay rulers signed a treaty called the Federal Treaty and created the Federated Malay States. However, this federal treaty is also not a federation in the modern sense. Okay, so it creates a federation, but it's actually for the purpose of attaining efficiency in administration and fulfilling economic aim. All right, so the amalgamation of the 4 states, as I mentioned just now, was only limited to administrative, legal, and financial aspect. So after the Second World War, we have like 3 administrative units in Peninsular Malaysia. We have the Federated Malay States, Unfederated Malay States, and also the Strait Settlements. So it is difficult to administer, and to make it easy for the British colonial rule to administer, so they sort of disbanded with all those administrative structures and created the Malayan Union. However, the Malayan Union was strongly opposed by the Malays, okay, because the effort of establishing a unitary state, basically making the Sultan is just like a puppet. So the people renegotiated with the British colonial rule, and finally they came to an agreement which we call Federation of Malaya Agreement in 1948, which is a compromise formula from the 1946 Malayan Union proposal. So this is actually the real how do you say, penetration of federal system in Malaysia, the modern federal system in Malaysia, whereby the agreement created a strong central government and accommodate the states and particularly the sovereignties of the Malay rulers. So about 9 years later, because 1948, it was understood that the 1948 Federation is actually a stepping stone towards independence. So in 1957 or before that, the British colonial rule appointed commission to draft the Malayan independence constitution, and therefore created the Federation of Malaya in 1957, where we had 9 states, and then the states have certain measures of financial autonomy and certain exclusivity for the both and federal states in certain circumstances, and they safeguard the states in the form of Senate powers in the constitutional amendments. And later on, the Federation of Malay expanded in 1963, to include Sabah, Sarawak, and Singapore. But later on, Singapore left Malaysia in 1965. So that's basically the history of the Malaysian federalism in 2 slides. Okay, so just to give a rough idea for the students who are not familiar with the history of Malaysian federalism. So why do we need federation? Okay, in the Malaysian context, there are 2 reasons, two situations. First, in 1957, why did we establish a federation? Because one of it is to preserve the sovereignty of the Malay rulers and to uniform the development among the various states in the peninsula, and also a preparation towards self-government. And in 1963, the creation of Federation of Malaysia is to balance the ethnic composition and to prevent the spread of communism. Okay, so based on what I explained in the earlier slides, what was explained about the features of federalism. So I narrowed down the 5 features of Malaysian federalism. First of all, we have distribution of powers between the federal government and state government. Each state has its own sovereign rules with its own constitution and legislature. Each state has a written constitution. We have a federal constitution, a written constitution which outlines the distribution of power, and states also has its own constitution. States have its own flag, its own crest, and public servant. And there's a court, okay, acting as an umpire between the federal and the states. So this is basically the structure that we have. So the federal constitution, I put it up there because in our constitution, the federal constitution is the supreme law of the land. So the structure is originated from the federal constitution. And even though we said there's 2 levels of government, but actually in the definition of a federal system, it's actually a partnership between the state government and the federal government. Neither is higher than the other. And after the governments, we have the distribution of powers, we have the list, the federal list, state list, and concurrent list, and the 4 distribution of powers. So these are basically the provisions in the Malaysian Constitution with regards to federalism. I'm not going to read it all. You can just Google Malaysian Constitution or Federal Constitution of Malaysia, and you can get the whole bulk of the Constitution and the list with regards to federalism. I'm just going to highlight that Part 6 in the Constitution touch on the relations between the Federation and the states with 8 chapters. Okay. So these are the provisions, Article 73 onwards. Okay. Now I'm going to go just a little bit detail, just to share with you what is the scheme of distribution of powers. All right. So we have we have legislative lists. Okay, one is federal list, and the other one is state list, and another one is concurrent list. All right. So federal list, Parliament may make law in respect of matters in the federal list and the concurrent list. And the state list, state legislature may make law in respect of the matters in the state list and the concurrent list. Besides that, we also have residual powers, okay, whereby the state legislatures have the power to make laws on matters not set out in any of the 3 lists. And in the event of any inconsistency, our Article 75 of the Federal Constitution said that federal law will prevail over the state law. So this is what is contained in our 9th schedule of the Malaysian Constitution. So it outlines what are the powers distributed to the federal government, to the state government, and what are the powers shared between both of the government. I'm not going to read all of the items in the list. This is just to give you a snapshot, an idea how the power is being distributed in Malaysia. Okay. So I'm going to touch on just a little bit on legislative powers, executive powers, financial powers, and judicial powers. Okay, this is basically what is distributed between the federal and the states. Okay, however, with regards to judicial powers, okay, most of all the matters under the courts are actually courts under the federal government. So it governs all civil matters, okay, regardless whether the matter is under federal list or state list or concurrent list. So all the courts, the civil courts, we call it civil courts in Malaysia, govern all matters. For Sharia matters, it is governed by the state Sharia courts. Okay, so it governs differently, whereby the Sharia courts are owned by the states. All right, so it has a specific jurisdiction on Islamic matters, especially on family and other matters relating to personal matters. Okay. Right, distribution of legislative powers. Basically, the federal legislative powers is exercised by the parliament, okay, which has the House of Representative and the House of Senate. Right now, we have our parliamentary sitting, committee stage, discussing on our annual budget, 2021 budget. You can have a look at in YouTube, the Malaysian Parliament YouTube. The state legislative power is exercised by the respective state legislative assembly. And the Attorney General Chambers is the one who's responsible for the drafting of the legislation at the federal and state level. So the attorney, despite we said that it is a federal system, but we have only one Attorney General's office or chamber, which is responsible to draft all the laws, either at the federal or the state level, okay, including the Sharia laws. And distribution of legislative matters contains in the 9th schedule must be read together with provisions under Chapter 1 of Part 6 of the Federal Constitution. So we have Article 73, the territorial boundaries, and 74 with regards to the subject matter. So the items, I showed you the list just now, but it boils down to the federal government have 27 items, the state have 12 items, and the shared list is actually 9 items. Okay, executive powers. So Article 80 of our federal constitution provides that the federal government has executive powers in matters within its legislative competency, and the same applies to the state. For example, if the federal government has the power with regards to, for example, a public order, right? So that is the legislative and the executive powers of the federal government to enact law and also to execute the law. So the same applies to the states. For example, the states has the power with regards to Islamic law, Islamic family law matters. So the state has the power to enact the law and also to execute the law. So the federal government has the executive authority in matters provided in the federal list and the concurrent list, and vice versa with the state government. And so this is one of the challenges that I'm going to highlight at the end of my presentation. And however, despite the constitutional division of power, it is not absolute, okay, because there are many instances where the federal and the states have to work together in the execution of their power. All right, so now moving on to distribution of financial powers, okay. So this is, of course, again, a summary of what we have in our constitution, but I just divide the table into statutory grants and non-statutory grant. What I mean by statutory grant is that grants provided by the law, by our constitution, or by our federal act. Okay, as you can see, there are 7 statutory grants. This is, we can consider as compulsory grant that must be given by the federal government to the state government. We have all the calculation in our federal constitution. Okay, there are 7 capitation grants, state road grants, state reserve fund, assignment of export duty, revenue growth grants, grant to local authorities, and grant based on economic development, infrastructure, and well-being. And we have another 4 non-statutory grants, meaning to say it's not stated in our law, but it is discretion of the federal government. Contribution in aid, grants based on performance of the federal development project, advances, and loans. And this is the source of revenue for the states. Okay, just now was what the federal government must give to the states, and these are the revenues contained in the 10th schedule of the federal constitution. What are the revenues assigned to the states? Okay, there are revenues from land, licenses, entertainment, duties, fees in courts, revenues from town council, from local council, rents of properties, okay, zakat and treasure trove. So it's about 15 sources of revenue for the states in Malaysia. Yes, it's not a lot, definitely, but that's how it's been distributed in our federal constitution. Okay, so I just have a few more minutes because I told the organizer that I'm going to shorten my presentation so that it will give the other 2 presenters a bit more time. I'm just going to take about extra 5 minutes, okay, from the 20 minutes that I allocated to myself to explain about the 5 issues relating to Malaysian federalism. All right. So I narrowed down. There's a lot of challenges. There's a lot of issues. Okay, so I'm just narrowing down to 5 main issues. First is intergovernmental relations, operation of concurrent powers, fiscal federalism and distribution of wealth, the role of conference of rulers, and the role of Senate. Okay, each of these federalism issues, we can write a whole PhD thesis on it, all right? And I wrote my thesis on intergovernmental relations, so it's a very long discussion. So it's just going to this is just giving all of you, ladies and gentlemen, students, some snapshots of what we are facing in Malaysia. It is saying that I'm saying that despite choosing federalism as our system, it's not everything sunny, everything beautiful. There are certain issues that we have to address, and it's an ongoing process. Okay, it's not the best, but that this it may not be the best, but this is the most suitable for the Malaysian situation. Okay, what is intergovernmental relations actually? So intergovernmental relations is actually relationship between the federal government and the state government. So this is a term coined by many federal states in the whole world, and many federal nations in the world have advanced in their intergovernmental relations, where they have lots of mechanisms. So what is the purpose of intergovernmental relation? Is actually to establish proper cooperation, is to establish proper consultation and coordination in matters either within the federal powers or within the state powers or within the concurrent powers contained in the constitution. It sounds very ideal, right? But then we have all these bodies, statutory bodies and non-statutory bodies. We have the Conference of Rulers, which I'm going to explain later. We have National Finance Council, National Land Council, National Council for Local Government. So these three national council are all stated in our federal constitution, and we have other councils which are provided under the federal law. But I'm just going to highlight these four important bodies, and we also have non-statutory bodies. All right. What is the issue? The issue is that with this advancement of science and technology and communication, there's a lot of issues. All right. So this National Council only presides like once or twice a year, whereas there's a lot of issues governing finance, governing land, and local government. So it's a high time for Malaysia to relook how all these statutory bodies work to enhance our own federal system. Either it's a statutory body or non-statutory body. I think with the advancement of technology and with the current lockdown that all over the world we are facing now, it might be a good time to relook how does all these intergovernmental bodies operate. Next, the second issue is operation of concurrent powers, and I'm just going to highlight one popular issue in Malaysia: water governance. Right. So if you look in the Malaysian constitution, there is one item which is stated water supplies and services. It is amended. It was in the state list, and the constitution was amended to transfer water supplies and services into the concurrent list to enable the federal government to create a federal structure to coordinate water supplies and services throughout Malaysia. However, when we break down the source of power, the source of legislative and executive power, the whole table will tell you how complicated water governance is. All right. So it deals with federal 4 items on the federal list, 3 items on the state list, and 5 items on the concurrent list. And when we talk about lists, we also talk about the agencies involved in executing the powers under the respective list. So it's a whole complicated structure. Okay, and whenever there's a problem like water pollution, which disrupt the water supply in the states of Selangor for the past few months, so the blaming game starts, and then it's very difficult to find who is accountable and how do we rectify the situation. So this is one of the challenges that we face in Malaysia. Third issue is fiscal federalism and distribution of wealth. Okay, as you can see that when I touch about the financial distribution, you can see it's a bit lopsided. The federal government has more money, and therefore they have to give more grants, and the state government has very little revenue. So there are 2 issues I just want to highlight: is that there are different treatment by the federal government towards oil producing states, and the state of Kelantan is one of the states that was denied royalty. I don't know how many billions are royalty denied by the federal government, and but that was before 2020, whereby the federal government and the state government is ruled by different party, but now they have the same coalition parties. I don't know, maybe they are moving towards it, but with the COVID, I think everything is stopped, I guess. So the next one is about distribution of wealth, whereby you can see this is the absolute poverty statistics, okay, provided by our Department of Statistics of Malaysia. As you can see, we still have a high level of poverty in certain states. So the distribution of wealth may not be, how do you say, suitable or appropriate to the situation in the states. Okay, the role of the Conference of Rulers. This is the man in the blue is our Yang di-Pertuan Agong, who is the chair for the Conference of Rulers. So the Conference of Rulers is another element in the operation of Malaysian federalism and separation of powers in Malaysia. So it is the highest body in Malaysia outside of the government structure, and there's a lot of important roles that could be played by the Conference of Rulers, especially with this unstable political situation in Malaysia. So with regards to federalism, there's a lot of role that the Conference of Rulers could play. Last but not least is the role of the Senate. Okay, as I mentioned earlier, so we have the upper house and the lower house. So the Senate is the upper house. So there are 26 Senate members appointed by the states for the purpose of preserving the rights of the states. However, if you look into the Malaysian Parliament website, you can see that the numbers of the Senate members appointed by Agong, okay, is larger than the members appointed by the states. So how could the 26 Senate members play their role in preserving the rights of the states? Okay, so what is the solution? Just briefly, okay. States should be given equal treatment, and both the federal government and the state government should adhere and observe by the Schedule 9 of the Federal Constitution. And maybe it's a high time for the states in Malaysia to be given more power rather than what we have now, and then there should be more intergovernmental discussion, really, and a much more stronger relationship between the federal government and the state government. Australia had a review of their federal constitution and their federal system after they reached 100 years. So maybe Malaysia does not need to wait 100 years to review our federal system. Maybe it's a time for us to have a constitutional reform on how we do our federal and state relations. So that's it. My sharing session with all of you. So I pass over to the chairperson. Thank you very much. Assalamualaikum.
Waalaikumsalam warahmatullahi wabarakatuh. In Malaysia, Dr. Nur Hafila already presented about many things, very informative to all participants, to all students regarding of the federalism in Malaysia, the structure, the challenge faced by the Malaysian government, and also the solution that Bu Dr. Nur Hafila offers. Maybe for all participants, if you wish ask the questions regarding this issue, just write down your name and your institutions and the questions in the chat box. And now we are moving on to the second speaker from the Brawijaya University, Ibu Prisca. Are you ready?
Yes, Ibu Dr. Rika Kurniati. Could you hear my voice?
Yes, okay.
All
Ibu
right.
Prisca, the time and screen is yours.
All right, everyone, let me share my screen. Is it appeared already?
Yes.
All right. All right, good afternoon, everyone. Assalamualaikum warahmatullahi wabarakatuh. Before I start my lecture, first I would like to express my gratitude to all the committees of this joint class program from Brawijaya University and also from Universitas Kebangsaan Malaysia, particularly for Ibu Dr. Afifah Kusmadara and all the teams that already make an extra effort to make these lectures happen. Then secondly, I would like to greet our head of department, Ibu Dr. Indah Dwi Kurbani, because I'm coming from the Constitutional Law Department and currently she is the leader there. And I also would like to greet all the colleagues in UKM, particularly to Associate Professor Dr. Sahrul Bizan Ismail, because we have experience 2 years ago. He came to Brawijaya University and provide a series of lectures under the 3-in-1 program to the Constitutional Law Department. Thank you very much for coming to us. And now finally, we meet again in this joint class session between Brawijaya University and OKM. So without taking other further ado, today I'm going to present you about the committee asked me to present. The topic is federalism in Indonesia, but maybe today is not quite something they called as federalism. So it is just my background, skip it because Burika already introduced me before. So here, what is federalism? So federalism is a concept of government. As the previous speaker already told us, it talks about the distribution of power between the central and the local government, or between the two-tier system, the national level and the provincial or the regency level. So usually the federalism is called to for the state who are using a system of federal like Malaysia. But in Indonesia, according to Article 1.1 of the 1945 Indonesian Constitutions, it states that the state of Indonesia is a unitary state which in the form of a republic. So as we use the form of state is unitary, not federal. So maybe for my presentation, I prefer to call it that today I'm going to deliver you about Unitarianism in Indonesia. Why? Because I always taught by my lectures previously when I was in bachelor study that in principle, the federalism and the Unitarianism is the two competing ideas of the formulation of the states. And between the two systems, there is a fundamental differences between the two. So what are the differences? First, in the unitary state, the original powers are owned by the central government, but then in the federal system, the original power is actually owned by the federating units or by the state. That's why in the federal state, as like in Malaysia, between the two parties, they have their own constitution. It is not the case with Indonesia. We only have one constitution, the 1945 constitution, that regulates about the nations, and there is no other constitutions. That is the number one differences. And the second differences is in principle, the unitary state, they are more centralized than the federal state. Why it is centralized? Because as I told you that the original power is owned by the central national government. And oftenly in the unitary states, all the services are delivered by the central national government. If you want to have a comparison, maybe for the Singapore, the central government deliver all the services within the nations. But maybe it is not the case for Indonesia or any other nations that the territory is so wide and we also have thousands of islands and hundreds of ethnics. So maybe the case will be different. There is a challenge for the centralized principle in the unitary system of Indonesia. And then the third is the other differences between the federal state and the unitary state is, as Ibu Dr. Nur Hafila has presented us before, that the list of powers in the federal states are often listed in the constitution. At least what I have seen from the Malaysian constitution and also from the Australian constitution. In the constitution, they listed powers that is belongs to the central or to the federal government and to the state, and the concurrent list between them. There is comprehensive list in the constitution. But in Indonesia, in the constitution, we only listed the principles of the relation between the two units, the central and the local. But then for the list of powers, usually we regulate it in an act, which is a regulation under the constitution. Why it happens? Why we do not list it in the constitution? Because as I said, that the original powers is in the central government, so they can easily just change the list of powers time to time. For instance, the nowadays of the Local Government Act is Act number 23 year 2014, and the previous one was Act number 32 year 2004. So we can see that in these 10 years or during a decade, we changed the list of the powers between the central and the local government. So the list would be changing time to time. And it is easier to change an act than to amend a constitution, usually like that. And other examples of unitary system, there is also United Kingdoms, France, Japan, and United Kingdoms. I think it's almost the same with Indonesia, because in United States, although this is a unitary system, but they have a decentralizations to each provinces, and they even have a devolution there. Okay, now we are going further to Indonesian constitutions. So under Article 1.1, as I told you that we are a unitary state, then under Article 4 to 17, basically it tells that we are the presidential system, and it is another differences also between Indonesia and Malaysia, that I think Malaysia using the parliamentary system. That's why the Sultan or the king is just a symbol, like in the UK, but in Indonesia, the president holds power according to the constitution, not just as a symbol, but also as head of state and head of the government system. Then under the Article 18, we have a principle called the two-tier of local government. So here there is a vertical power division or distribution between the central and the local government. It states that in Indonesia, we have several provinces, and under the provinces, we have several cities and regencies, which each province, city, and regency, or we call it local governments, it has an autonomous power under the local autonomy system. So we call it as a general autonomy in Indonesia. Why we call it as a general autonomy? Because we have two types of autonomy in Indonesia. The first one is the general autonomy, and the second one is the special autonomy. And I will go into the details after this. So first one, I'm going to tell you about the division of affairs between the central and the local government under the general autonomy system. Under the general autonomy system, we have three types of affairs. The first one is the absolute, and then the second one is the concurrent, and then the last is the general affairs. So the absolute affairs is affairs that only exercised by the central national government. The local government cannot and may not occupy or exercise these affairs. There are 6 affairs that are listed under the absolute affairs. Once again, it is listed on an act or law number 23 year 2014, not in the constitution. What are that? The foreign policy, defense, security, judiciary, national monetary and fiscal, and religion. And the second one is the concurrent affairs. The concurrent affairs is an affair that could be divided by the central, national, and the local government. The local are the provinces and the cities and regencies. There are 2 types of the concurrent affairs. The number one is the mandatory government affairs, that affairs that should be delivered by each governmental unit, such as education, health system, social affairs, labor management, housing, transportation, and etc. And the second one is the preferred government affairs that could be delivered according to the conditions of its regions. It could be in a field of tourism, fisheries, energy and minerals, forestry, industry, agriculture, trade, and transmigration. For example, we are Brawijaya University in Malang. We have units that deliver affairs on tourism because we have tourism, but we don't have units that deliver an affairs of transmigration because we don't have the case of that in Malang. And then the last affairs under the general autonomy system is the general affairs. This is the authority that only delivered by the president as the head of government in order to maintain the national integrity and the harmony of the nations. It's also to maintain the democratic life of the nation. Often when there is like ethnical conflict or religious conflict, then the president as a symbol, he should do something in order to reconcile or harmonize the peace and orders. These are some affairs under the general autonomy system, and we have a system of harmonization between the laws and policies of the central, national, and the local government. As I told you before, that there are 3 affairs, and particularly the concurrent affairs, that is affairs that is delivered by the central and the local government, particularly or sometimes there is a conflict between that laws and regulations. And as it is stated in Malaysia that there is a conflict between the federal law and the state law, then the state law should be invalidated, and it is challenged in the court, I think. I think it is the same with the federalism in Australia, that if there is a conflict between 2 laws, then the court should invalidate the state law. But in Indonesia, there are some efforts that can be done if there is a conflict between the regulations of the central and the local government. The first one is through the executive review. So for a several local regulation bill, the central government could then review it before it is enacted, particularly in regulations that concerning to medium and long-term development plan, regional revenue and expenditure budgets, regional spatial planning, regional taxes and levies. And actually, we also have executive review when the central government could review all types of the local regulation, but then the constitutional court invalidate this regulation. So now we don't have the executive review. We only have the executive preview, although many commentaries on these invalidations. And one of that is a journal written by Professor Simon Bell. And other than the preventive effort, the executive preview, we also have the repressive effort through the judicial review going to the court. If the citizen thinks that any regulations made by the central government through the act is in contravene with the spirit of autonomy that is given by the constitution, so then the citizen or the local government can challenge the act to the constitutional court under the judicial review system. And secondly, if there is a local regulation that is made by the provincial, cities, and regional level that the citizen or the central government thinks that it's has a conflict or it's inconsistent with the federal law or with an act, so then they can challenge the local regulations to the Supreme Court. So we have kind of preventive and repressive type of harmonization of laws and policies between the central and the local regulations. So now we are going to the spatial autonomy. What is spatial autonomy? Spatial autonomy is autonomies that is different with the general autonomy scheme. And nowadays we have 5 provinces that were granted a spatial autonomy status by the central government. The number 1 is DKI Jakarta. Number 2 is Daerah Istimewa Yogyakarta, then Nangor Aceh Darussalam, Papua, and West Papua provinces. Why are they special? So for DKI Jakarta, as we know that this is the capital city of the state, so it has specific duties, rights, obligations, and opportunities that could be conducted because the buildings of the presidency is within the land, and also the buildings of the overseas embassies and also overseas countries are representative are in Jakarta. So there has to be a special fund to support its position as the capital city of country, as well as several powers. For example, the government can directly elect the mayor, which is it is not the case in under the general autonomy, because under the general autonomy between the governor and the mayor or the regency leaders are elected directly by the people, not by the governor. But this is not the case for Jakarta, whether the governor can elect mayors in its regions. And the second one is Daerah Istimewa Yogyakarta is given a special status on the ground of the culture. We know that Yogyakarta, there is a monarchy system there. We call it Kesultanan Ngayogyakarta Diningrat, that has a sultan and Paku Alaman. And sultan is directly appointed as the governor, and Paku Alaman is directly elected as the deputy or the vice of the governor. So without doing direct elections. And also there are special powers under the spatial planning, culture, land, and etc. And the other 2, it's for the Nangor Aceh Darussalam and Papua and West Papua. So the previous 2, the DKI Jakarta and Yogyakarta, they get their special autonomy status before the Reformation era. But the other 3, the Aceh, Papua, and West Papua, they just get their special autonomy status after the Reformation era. For Aceh, Aceh is given the authority to apply the Kanun law and also Islamic judiciary system. And so there is an existence of local party in Aceh for the local leader elections. And then in Papua and West Papua, they also given special autonomy as a result of political compromise in order to resolve multidimensional conflicts since 1962. Then through the political compromise, then it is given special autonomy to grant or to recognize the existing customary institutions, adat, hukum adat in Papua, and then to grant affirmative policies and actions to improve the capacity of the human resource in Papua. So then they need special fund for it, and they need special policy for it to enhance their educations, health, and also economic system within the land. Okay, this is the general autonomy and the special autonomy in Indonesia. And today my presentation is only focused on the relationship between the central national and the local government, and will be continued by Dr. Sahrul to talk more about Indonesian legal system. But before that, I'm going to quote the speak or of our first president of the Republic of Indonesia, Insinyur Soekarno. He said that this country, the Republic of Indonesia, doesn't belong to any group, nor to any religion, nor to any ethnic group, nor to any group with customs and traditions, but the property of all of us from Sabang to Merauke. So finally, these are the references. Wassalamualaikum warahmatullahi wabarakatuh, and I give the time back to the moderator.
Thank you very much, Ibu Priska, for very interesting presentations regarding the unitary system in Indonesia. So, ladies and gentlemen, Bu Prisca already presented regarding the distributions of power in Indonesia and the division appear between the central and the local government, and also if there is a conflict law between the central and the local government, what should be done. And also in the end, Bu Prisca also mentioned about the special autonomy, describe the special autonomy that given to 5 provinces in Indonesia. And I think there are many things to be discussed. So if you all have questions, just write down your name again, and then your institutions, and also the question in the chat box. Okay, that's all. And now we are moving on to the last but not least speaker, Bapak Syarul Sajidin. Pak Syarul, are you ready?
Yes, Bu Dr. Rika. Terima kasih.
The time is yours.
Yeah. Okay. First of all, I would like to thank you for the opportunity that given to me. Thank you, Ibu Dr. Rika, for the opportunity that given to me, and Bu Dr. Afifa and the team who helped this special joint class, and for the Ibu Dr. Nur Hafilah from the UKM and the other lecturer from the UKM, University Kebangsaan Malaysia. Maybe I want to share screen first, my PowerPoint. Okay, maybe I will make it fast because there's so many things shared by Ms. Prisca about our legislation, our constitution, and our spirit of power between the local and the parliament. So the overview. Indonesia is the biggest archipelago state, more than 1,300 islands that's spared by the sea, by the ocean. So there is made more than 300 ethnic and sub-ethnic. So if you meet the people, Indonesian people from the Java, maybe a little bit different from the language, from the accent, with the Indonesian people from the Sulawesi or from the Kalimantan, Borneo. There is so many different between us, but there is our characteristic, so we call it Bhinneka Tunggal Ika, united in the diversity, of course. So there is our resource and our challenge to make our country is getting better time by time. So for the local language, we have more than 600 local language. So each group develop its own customary law. In Padang, there is a different characteristic with the customary law that in Sulawesi, in Maluku, in Papua, there is so many different in our customary law. So, but the most is we in our law there is influence, so many influence by our colonial law, especially from the Dutch. So the history, I think I started from the Majapahit Empire because our principle like a Bhinneka Tunggal Ika, there is a written in old book that wrote in Majapahit Empire, maybe in 14th century. So we move on to the Dutch era from the 18th century and Japan era in 42 and independence era from 45 and the Reformation era in 96 that already described by Ibu Prisca. In the Dutch era, Dutch who established the Roman Dutch civil law. So there is a adopt by Indonesia in our civil law legal system. So I think there is maybe some critics for Indonesia because from our Independence Day until now we still use the law that from the Dutch like a criminal law and the private law. There is still the same law from our independence era. So the British rule for a short period from 1811 and 1816, but did not make significant change to the existing law. And the principal thing from the Dutch era is that population was divided into three classes: the European, the foreign oriental, and the indigenous. This is a strategy that do by the Dutch for facilitate that their political and economic interests. So sometimes they have so many advantage because some indigenous people doesn't know how about the European law. There is so many problem when so there is a give so many advantage for the European people to get some land, to build some farm. There is so many things. So there is a strategy that do by European to accommodate their trade and political economic interests. And the next is Japanese era. They came to Indonesia, introduced themselves as the leader, the protector, light of Asia, and older brother. Or in Indonesia we call it saudara tua, saudara tua. So, but Japanese just focus to their vision, to their mission, to control whole of the Asia. So they not make a big change in legal system because they do some military approach. But the true legacy that give from the Japan is the political life, the administration, and the military. In Dutch era, for indigenous people, we doesn't have a political life. We doesn't have control to administration, to involve in administration. But in Japan era, Japan gives some opportunity for indigenous people, for the local people to contribute in the politics, contribute in the administration, and to contribute in military things. So, nah, this is from our independence, according to the transitional provision, Article 1 and 2 of our Constitution, 1945 Constitution, that all legislation and institution from the colonial period remain valid and in place until they are revoked and replaced. But until nowadays, there are so many colonial legislation doesn't replace this. This is a big problem. Most colonial legislation are still valid with revocation of particular article or body of law even until now. So reform era, this is so many big change in Indonesia from the Reformation era in the 1998. Our constitution amended 4 times in October 99, August and 200, November 2001, and August 2002. There is so many big change in our political life, in our human right protection, in our local government regulation. There is so many different before Suharto and after reform era. So there is this amendment deal with far-reaching issues such as limitation of power. Before it, the president limitation time, this is not limit, but now and from the amendment, just 5 years and can be elected at least at once to the second period. And the centralization of central government authority to provincial and regional government. And in the first time of the Reformation era, there is so many debate about our decentralization. Are we come back to the or we choose to the federal system, same like Malaysia, or we choose local autonomy like Papua, like Nangro Aceh Darussalam, or we just choose local autonomy. But in that time we choose just a local autonomy because there is so many problem and there's so many political issues at that time. I think we are already knew in first of Reformation era, we lost our territory, some of our territory. Now we call it Timor Leste because there is so many different and so many problem in course of Reformation era. To the legislative power is held by the House of Representatives. We call it DPD, Dewan Perwakilan Rakyat, or in Malaysia we call it Senate, who are chosen through general election every 5 years, which also hold equal position toward other state institutions. In the other hand, DPR power extend beyond the narrow interpretation of legislating or lawmaking process. It also holds the budgeting authority and the more important function of representing the people in supervising the executive power. On several authorities, the DPR and DPD congregate as a people consultative assembly. We call it Majelis Permusyawaratan Rakyat, which consists of the member of DPR and DPD. This is a joint. They are joined among the function. There's just a limitation function, just a amending of the 1945 Constitution, appointing president or vice president in the case of vacancy in the position, inaugurating the president and or vice president, and to impeach the president and or vice president in accordance with the 1945 Constitution. With the assistance of MPR as a separate entity, juris ascribe Indonesia legislative power to tricameral as opposed to bicameral. And judicative, the judicative power developed as one system which culminates at the Supreme Court. We call it Mahkamah Agung, and the special for the constitutional problem, we call it Constitutional Court, and we call it Mahkamah Konstitusi. The Supreme Court decided the petition for cassation against the decision of the court at the appellate level or the last level of the court, because in Indonesia we have a 3-level court, from the district court, the high court in the each province, and the Supreme Court in the state level. The Supreme Court is a main regulation with majority against statutory regulation under the law, under undang-undang, di bawah undang-undang, under the law, carry out the highest supervision of the administration of justice in all area of the judiciary in the administration of judicial process. And the next is Constitutional Court. This is process from our constitutional changing, testing the law against the 1945 Constitution of the Republic of Indonesia, resolving dispute over the authority of the state, deciding the dissolution of political party, resolving dispute about the result of general election. So there is so many case in Constitutional Court. This is the mostly is resolving dispute about the result of general election, and to testing the law, undang-undang, against the 1945 Constitution of the Republic of Indonesia. So there is just the most case in the Constitutional Court, and Constitutional Court just one in Indonesia, and do by 9 judges, 9 hakim konstitusi. Hierarchy, the hierarchy of the law in Indonesia, it is the highest is the Undang-Undang Dasar 1945, the 1945 Constitution of the Republic of Indonesia, and below it stipulation of the People Consultative Assembly TAP MPR. But nowadays MPR doesn't have authority to make the new TAP MPR or the new stipulation of the People Consultative Assembly. And the next is the law, undang-undang or government regulation in lieu of law, Perpu, peraturan pemerintah pengganti undang-undang. And the next is government regulation, presidential regulation, regional regulation, we call it peraturan daerah in each province. And the next is regency or city regulation, we call it peraturan daerah kabupaten kota. Adat law in Article 18B, paragraph 2, second paragraph of our constitution, the state recognize and respect customary law, community, and their traditional rights. So there is so many adat community in the Indonesia, like in Baduy in West Java, suku anak dalam in Sumatera, suku Dayak in Kalimantan. There is so many adat law community, and the state got to respect customary law and the principle of the unitary state of the Republic of Indonesia. And the next is Islamic law. In the legal system in Indonesia, the position of Islamic law is the same as a customary law and Western law. But some law in Indonesia, like a marriage law for the Undang-Undang Nomor 1 Tahun 74, there is so many Islamic perspective, like a polygamy that rule in that law, and so many things that the Muslim characteristic in the Undang-Undang Perkawinan Nomor 1 Tahun 74. And Sharia banking, special for the Sharia banking that regulated by Undang-Undang Nomor 21 Tahun 2008. And legal profession in Indonesia, there is maybe judge, prosecutor, lawyer, or advocate and notary. But special for the foreign, just lawyer or advocate that can do by the foreign. So the requirement to be lawyer in Indonesia in litigation process, but just in litigation process, the first is being a part of a local law firm or local law office, and the second is get some bar recommendation from the Peradi, Perhimpunan Advokat Indonesia, and of course that recommendation given to those who pass the examination for foreign lawyer. And the last requirement is provide legal service free of charge to the Board of Education and Legal Research at least 100 hours per year. At least maybe if we compare it with the case, maybe at least more than 2 until 3 cases per year for the pro bono cases. So this is my presentation. I will send it back to the Ibu Dr. Rika. Thank you.
Thank you, Pak Syarul Sajidin, for interesting presentations regarding the national legal system. Before move on to the question and answer sessions, I kindly ask participants to give virtual clap or thumbs. You can click in the bottom reaction here. Okay, now for the Q&A sessions, we have already get many questions, several questions. Maybe for the first session, I will open 2 sessions and I will deliver the question. I will read the question. The first for Dr. Nur Hafila. The first questions came from Ibu Afifa from Brawijaya University. There are 3 questions addressing to Ibu Dr. Nur Hafila. The first question is, can a state in Malaysia borrow money directly from the IMF or the World Bank? And the second question, can a state in Malaysia make an agreement with other foreign parties without the involvement of the federal government, such as agreement with foreign private investor? And the third question, if there is a dispute in that relations, who will go to the tribunal such as ICSID, the state or the federal government? That's a question for Dr. Nur Hafila, the first questions. And the second question for Dr. Nur Hafila as well, from Zafran, from Universitas Brawijaya. The question is, before 2011, Queen of England and the Commonwealth has a power given by the law to dissolve the parliament. Is yang di Pertuan Agong also has that kind of authority? And the second question from Zafran as well, is a provisions about referendum known in Malaysia? If it is, in what kind of aspect the provision could be applied? Thank you. And now the question to Ibu Prisca and Pak Syahrul. I read two questions each for this session, and then we'll be continue to next questions. The first question is from Balkis from University Kebangsaan Malaysia. The question is there any situations where overlapping of power occur between those special autonomy? So yeah, it's like overlapping of the power. And the second questions from Sari from Brawijaya University to Miss Prisca also. Do you think that federalism fits Indonesia? I think that's for this first Q&A sessions. I think both Bu Prisca and Pak Syahrul, you can answer these questions, the last two questions. Okay, for the first time, I will give the time to Dr. Nur Hafila to answer those two questions, and then will be continued by Bu Prisca and Pak Syahrul.
All right, thank you very much for the questions. Okay, so for the first question, can the state Malaysia borrow money directly from IMF? So according to our Federal Constitution, Article 111, 1, the federal 111 clause 2, okay, a state shall not borrow except under the authority of state law, and state law shall not authorize a state to borrow except from the federation or for a period not exceeding 5 years from a bank or other financial source approved for that purpose by the federal government and subject to such conditions as may be specified by the federal government. So in short, basically, state cannot borrow directly to foreign entities. Okay, so it is all regulated by the federal government. Second question, can a state make an agreement with other foreign parties? Referring to our ninth schedule in the Federal Constitution, item 1, external affairs. So it is the power, the executive power and the legislative power of the federal government to enter into treaties, agreements, and conventions with other countries and to implement the treaties and the agreements. So it is not within the power of the state government to do so. The third question, if there is a dispute in that relation, in relation with foreign parties, so it is the federal government which is responsible to deal with such matter. Okay, the second question just now from Mr. Zafran. With regards to the power of the Yang di-Pertuan Agong to dissolve the parliament, there are two provisions in relation to that issue. First of all, our Article 43, Clause 4 of the Federal Constitution provide that if the Prime Minister ceases to command the confidence of the majority of the members, unless at the request of the Yang di-Pertuan Agong, the Prime Minister shall tender his resignation. So if in this situation, if the Prime Minister does not have the command of the majority, he can advise the Yang di-Pertuan Agong to dissolve the parliament, or else if it's not if his request is not been granted, the Prime Minister shall tender his resignation of the cabinet. That's the first situation. The second situation is the normal situation under Article 55 Clause 2 of the Federal Constitution. The Yang di-Pertuan Agong may prorogue or dissolve the parliament. And the time span of the lifespan of our parliament is 5 years. So after the expiration of 5 years, so the parliament will dissolve automatically. And when the parliament is dissolved, then the general election shall be held within 60 days. So all the dissolution is usually done at the advice of the prime minister, because under Article 40, the Yang di-Pertuan Agong or the Sultan has to act upon advice. So if there's the last question is there a provision on referendum known in Malaysia? No, there is no provision in our constitution with regards to referendum. Okay, so I guess that's it. I see there's another 3 more questions for me, so I'll just pass it on to the chair to continue. Thank you.
Okay, maybe Bu Prisha and Pak Syahrul may respond to the questions.
All right, thank you very much, Ibu Dr. Rika Kurniati. So the first question is about overlapping power between the spatial autonomy. So as I told you before that within the spatial autonomy regime, usually it is regulated in a special act or law. For instance, DKI Jakarta, the spatial autonomy is translated or regulated in law number 29 year 2007. So there is a special regulation or special acts on what are the powers that is listed under the special autonomy. So it is then reduce the conflict itself, because the conflict actually there are frequent conflict is the relations between the central and the local government usually is not in the special autonomy, but in the general autonomy regime. Usually the conflict is in the general autonomy, because in the special autonomy, it is only, there is a bold line between the powers of the two, and it's listed in a detailed way in the act. Each special autonomy has its own act, so it is already very clear. But the issue is not the overlapping of power between the two units, but the issue is whether the central government is truly support the implementations of the spatial autonomy. Maybe this is the case of Papua and West Papua, because there are several powers and regulations in the law number 21 year 2001, Junto Law number 35 year 2008, that is not really implemented to the present until 2020. For instance, in the act, it is stated that in Papua has its own local election that has its own local party. So they can make a party that it's local for the Papua itself, and not the party that operates in the whole of the nation. But to the present, there is no detailed regulation on it, or there isn't delegated legislation for it. There is no further regulation about it. That's why Papuanese cannot apply it already. So the problem is not overlapping powers, but whether the central government really 100% support the implementations of the law. That is for the spatial autonomy. Then the second is for whether federalism fit Indonesia. If you ask me, I personally say that unitarism is the best one. Why? Because Indonesia has a very long history of decolonizations by the Dutch. 350 years colonized by the Dutch, and during their colonialization, they applies the politics of divide et impera, or divide and conquer, whether they try to divide us and then to conquer each other. And also in 19 let me check. In 1949, 27 December 1949, Indonesia used the federal as a formulation of the state at that time, because of the output of the agreement with the Dutch. they will give back Papua to us, but we have to change our state formation from unitary to federalism. And one of the reason is to again divide us, because within the federal system, I think it is easier for a state to get a referendum and to out from the federalism. But in the unitary state, for example, like Scotlandia, they want to spare it from the United Kingdom. It is very hard. Then they have to make a referendum that is permitted the uh, by the central government, and finally they end up with coming back to the UK. It's the same with Indonesia, because a unitary state is the choice that make us together, and it is harder for any province to act independence or to moving out from the nation. It is one of our effort to maintain our unity and integrity. Maybe that's my answer, Burika.
Thank you very much. Maybe if Pak Syahrul have something to add.
Yes, Miss Ibu Dr. Rika, I have some add of Ibu Prisca answer. And maybe there is not the most problem is not the overlapping between local government and the central government, but in my notes, the biggest problem is so many people, so many area push their government to get some special autonomy too from the central government. In my notes, the Bali people want to special autonomy from the central government. The reason for supporting tourism, and Kalimantan people want to special autonomy too because the reason is how to can control their natural resources, because and in special autonomy the biggest problem is there is so many area, there is so many people want to special autonomy too in their area, like Kalimantan people want to special autonomy because they think they have so many natural resources. Bali people want to have some special autonomy because they think there's some regulation that can support their tourism. I think I can say it in this forum, like alcohol, like the other, so they can to develop their tourism. So there's so many problem, but I think our government just stop special autonomy just in that area that said by Ibu Prisca, like in the Aceh, in the Papua and West Papua, in Yogyakarta, and in Jakarta. So there is I think the most problem is how to regulate about the requirement to the province or to the local government that can get some special autonomy. So there is so many problems because I think in each year there's some maybe I call it a local political actor to push their area, their province to get some special autonomy from the central government. So there is the main problem because until nowadays Indonesia doesn't have concrete requirement to get some special autonomy. So there is, because I think the special autonomy that given to the Papua, that given to the Aceh, there is a cause of a political reason, not just regulated in special law and special undang-undang. So there's just because Aceh and Papua, as you know, challenge our government to spare it from the Indonesia. So I think the special autonomy given because of a political reason, not a law reason. I think that's to complete the Ibu Prisca answer. Thank you.
Yeah, thank you, Pak Syahrul, for add the response from Ibu Prisca. And thank you, Dr. Nur Hafila, Bu Prisca. And we still have time about more than 20 minutes, around 25 minutes. And now we are moving to second period for question and answer. I will read the questions. 2 questions for each speaker. The first 2 questions are going to Ibu Prisya from Septantia from University of Brawijaya, Universitas Brawijaya. The question is regarding the special autonomy. We know that Indonesia currently in progress to move the capital to Penajam Pasar Utara, which is in East Borneo. Currently, East Borneo doesn't have the special autonomy. When the capital fully moved there, does East Borneo will have a special autonomy like DKI Jakarta now? And does it mean the special autonomy in DKI Jakarta then will lose? Okay, very interesting questions. And the second questions from Aimi from University Kebangsaan Malaysia. She asked about why the president doesn't have prime minister. Because if we look at the Singapore system, the president has its prime minister. Okay, that's the questions for Ibu Prisya. And there is specific question for Pak Syahrul from Maheswari. He is from Brawijaya University. The question is about, okay, I will read it. As mentioned before, every religion in Indonesia still have their own adat law. How does adat law develop in this era? So yeah, is every adat law still recognized? And how does the positions of national law in that regions? What if there is a conflict between adat law and national law? Yeah, it seems a lot of questions in one time. And the other 2 questions for Dr. Nur Hafila from Nanda from Universitas Brawijaya. Dr. Nur Hafila, okay. Headlines have emerged on issue of federalism, specifically on the successions of Sarawak and Sabah. What are your views on this? Does the federal constitution provide succession? And the last questions, not the last, but these 2 questions in these sessions from Shaukina, Brawijaya University. How Malaysian immigration system between one state and another state? Okay, I think that's all the questions for all speaker in this second session, Q&A second sessions. Maybe I will ask Bu Prisya first to answer the questions, and then Pak Syahrul, and then will be continued by Dr. Nur Hafila. Okay, the time is yours.
Thank you very much, Ibu Dr. Rika. So the first question is about the moving of the capital city of Indonesia from DKI Jakarta to Penajam Pasir. So what about the special autonomy then? It is going to be lost for the Jakarta and we will moving to Penajam Pasir. Actually, the issues now, there are several scenarios for it. The number one is both will get special autonomy. Because the capital is moving to Penajam Pasir, so then Penajam Pasir is becoming the special autonomy as a capital city. That is the scenario number one. And how about Jakarta? It could be still have the special autonomy. It could be it hasn't. Why it is still has an opportunity to has a special autonomy? Because currently Jakarta is the central of trade and economic development of Indonesia. And and industrial and many things of our economic resources are currently still there. And it is impossible to be moved to Penajam Pasir because I heard that the thing that will be moved, it's only the government building. Anything about the trade and economic still will be on Jakarta. I imagine it is going to be like New York with Washington DC in America, in United States of America. Previously, the capital city was in New York. Now New York, it's becoming a city of trade and economic development. Then the capital city is moving to the Washington DC. Maybe Jakarta and Penajam Pasir Utara will be like that. I see that in the future, but I'm not very sure about it because I'm not the one who take the decision, honestly. So that is to answer number one. And the second is why the president of Indonesia doesn't have prime minister. To answer that, we have to differentiate between the two terms. The first one is state formation, or in Indonesia we call it as bentuk negara. And then the second one is government system, or in Indonesia we call it as sistem pemerintahan. These are the two different terms. The first one, the state formation, is actually talking about the relationship between the central and the local government, or the federal and the state. If the correlation, the one who has the power is the central government, and it is centralized, then we can call it a unitary state like Indonesia. And if the nation only has one constitution, and if the original power is owned by the state and the central government only occupies several powers that already agreed by the uniting units or the uniting states, we call it as the federal state. And Indonesia is a unitary state. Also, Singapore is unitary state. In that regards, we are the same. But according to the governmental system, there is a differences between Indonesia and Singapore. Indonesia is presidential system like the United States of America, where the executive and the parliament in the same level, and they occupy their own powers, and there are the separations of power between usually three branches of power: the legislative, the executive, and the judicative. And the same as the United States of America, the heads of the government act also as the head of the state. This is the presidential system. There is only one figure that leads the nation as the head of the nation and as the head of the government. This is the governmental system of Indonesia. But the governmental system of Singapore is not presidential. It used the parliamentary system. I think it is the same with Malaysia. Malaysia also used the parliamentary system as well as Australia. In the parliamentary system, the prime minister oftenly doesn't directly elected by the people like the presidents in the presidential system. The prime minister is elected by the parliament, where the parliament is usually directly elected by the people. And the executive leader is under the supervisions of the parliament. And also the prime minister is usually elected by the parliament. That is the parliamentary system. And the Singapore using that parliamentary system. That's why they have president and also they have the prime minister. It is not the same with Indonesia, where we are the presidency system. We only have one president as the head of nation and head of the government that is directly elected by the people. That is my question, my answer, Ibu Rika.
Thank you, Bu Prisca. Maybe Pak Syahrul could answer the other questions regarding the adat law in Indonesia.
Okay, thank you, Ibu Dr. Rika. And for the adat law, still implemented, especially in the private law sector, because every judge in each area should consider the value that is in the society. for the example, the judges have different consideration between inheritance case in Padang or West Sumatra and Java. There is maybe there is a big difference between West Sumatra or Padang people inheritance cases between West Sumatra and Java, because Padang people use maternal principle. So which girl get more inheritance than the boys. So the girls get two part and the boys just get one part in the inheritance. So adult law is special for the still implemented, especially in the private law. So each judge that in each area got to know and to get the value from the society, because the judge got to consider the value that is in the each society, and each area, each region, each city in Indonesia has different value, especially for the private sector, especially for the inheritance cases. And for the national law, still used for the criminal law, for the crime, because still use the consideration is to ensure the legal conduct. So because in my hometown from the Borneo, there is some like a adat law that if we hit some dog, we got to give some compensation for the owner for with the goal. So there is a problem that we use the adult law like that to the our national law. So especially for the adult law, still implemented, especially in the private law in each area in each city. So the judges got to know, got to have some knowledge about the value that have in each city and each people. So there's maybe a little bit different between Sumatra people and Java people, Sulawesi people, and Kalimantan people, especially in the private law, especially for the heritage cases. Thank you, Ibu Rika.
Thank you, Pak Syarul, for the response. I hope they answer the questions. And now I give the time to Dr. Nurhafila to respond to the questions.
Okay, thank you very much. I had some time to look through the questions. First of all, the third question with regards to immigration. So there is no immigration system between the states in Malaysia, except for Sabah and Sarawak in Borneo, whereby the state government has the power to decide who can enter and who can enter the states. So for example, we had if they are, how do you say, dislike certain politicians from Semenanjung, from the Malaysian Peninsula, then they can ban that politician from entering the states. Okay, so basically between the states, we can freely move without using any passport. The fourth question is about factors that make Malaysia suitable to use the government system that has been explained based on social, cultural, and political aspect. So I just narrowed down into three factors: our historical factors, our political factors, and our geographical factors. So our historical factor is that the states in Peninsular Malaysia has been part of a larger Malacca Empire, Malacca Sultanate Empire. So basically, most of the sultans are actually how do you say, related to each other, right? So historically, we came from the same empire, part of the same empire. So even if despite the colonialism that we have gone through for like 300, 400 years, so we are still very much how do you say, part of each other. So that's why being in a federation, it suits Malaysia. And with regards to political factors, if we break down Malaysian Federation into smaller units, right? So the smaller units are quite small, and it is not strong enough. It's not strong enough politically in terms of defense, in terms of economy. So politically, to be strong, we need to unite all these small constituent units to become a federation. the third factor is geographical factors, because all the states are closely located to each other. So the how do you say, the best way to move forward is to be together, right? Orang Melayu ada satu pepatah, berat sama dipikul, ringan sama dijinjing. So we move together if it's whether it's difficult or it's easy. For example, during COVID-19 time, so we move together as a state so that the geographical factor made us close to each other. Okay, should I just proceed to address the rest of the questions, right? So Davin asked about what is the original intent behind the Malaysian Constitution, referring to the terms of reference given by the British to the Reid Commission report in drafting our constitution. There are 4 terms of reference. First of all, to provide a strong central government with a measure of autonomy. So that's why Malaysian Federation is a very centralized federation. The second one is to safeguard the position of the Malay rulers as constitutional monarch. So we have a constitutional monarchy system in Malaysia. The third one is to create a common nationality for the federation. So Malay, Chinese, Indian, and other races have a common nationality in Malaysia. And the safeguard the position of the Malays and the legitimate interests of other communities. So that is basically the original intent behind the drafting of the Malaysian Constitution laid down in the terms of reference in the Commission report. Second question from Devin is the participation behind the amendment to the Malaysian Constitution? If you look literally inside the Malaysian Constitution, there is no public participation provision anywhere. However, if you look into the reading process of the law, we have the first reading, the second reading, and the third reading of all bills. So basically, first reading is to, the purpose of the first reading is to notify the public the intent of the government to enact certain laws. The second reading is basically the government will read out all the provisions of the law, and usually the discussion at the lower house will take part at the second reading. As you can see in the latest budget, Malaysian annual budget in these few weeks, okay, you can see that yes, there is no direct public participation, but with the advancement of social media, the ministers could how do you say, recognize or identify the public response, okay, through social media, what the public would like to have more or what the public would not like to have in the budget or whatsoever. So that, I think the social media assists a lot in public participation in the lawmaking process. So the lawmakers at the parliament would take into account what the public would say through the social media, either through Facebook, Twitter, or even WhatsApp or Instagram, whatnot. So they would have a consultation at the parliament. The third one is what happened if the Senate and the executive power come from the same political party. How to handle that in order to prevent misuse of authority in the Malaysian government. So far, first of all, not all the members of the Senate come from the same political party, because we have certain criteria for a person to become a senator. So not all the senators are from the same political party as those who are in the lower house. So throughout the Malaysian political history, there is always opposition members in the lower house or the upper house. So even though during the time where the lower house have 2/3 majority, there is still opposition in the lower house to oppose whatever the government is doing. So it's not easily bulldozing whatever that the executive wants to do. And in case of there is any misuse of authority or abuse of power by any executive, then Malaysia have its Malaysian Anti-Corruption Commission that is in charge to deal with any abuse of power. And now with the advent of media, social media, of course, if there is any issue, then the netizens will always raise up whatever their dissatisfaction with the government. Next is with regards to autonomous state, like in Indonesia. No, we don't have any special autonomous state or special autonomous area in Malaysia, though we don't have. And Tutut asked about military court, whether the military court have civil court with in judicial powers. Military court is considered as a special court with federal powers. It is only under the federal statute which governs the powers of the military court. I think the last question was with regards to secession, right?
From Ibu Nanda,
With regards to
secession, Sarawak and Sabah.
okay, we don't have any provision on secession in our constitution. However, taking into account how Singapore left Malaysia, what was done was basically to amend our Article 1 and to delete the word Singapore from our constitution. So that was what was basically done in 1965. It was not there is no special provision of secession in our federal constitution. It was done through constitutional amendment under Article 159 of our federal constitution. Okay, I see there's I think one more question. Should I answer it now or later?
Yeah, okay, maybe we still have a little time. The
Okay.
Article 81 of Federal Constitution.
All right,
to executive federal, yeah.
Our federal constitution, we have the 9th schedule. So basically the 9th schedule provide the executive power and the legislative power for the federal government and the state government. So if you want to know how much power does the federal government have, you look at the Federalist. So the federal government basically have all the powers to enact any law under the Federalist and to execute any law under the Federalist and also under the concurrent list. So vice versa to the state government. How do you know how much the state government has, the power that the state government has? You look at the state list. So as I showed to you in my slide just now, the state government have very less power than the federal government. So that is the power for the state government to enact law and also to execute the law. All right. So that is basically it, I guess. I'm done with answering the questions.
Yeah, thank you very much for the response. I think very informative and answer the question from the participant. And, well, we have less than 5 minutes. So I think that's the end of the Q&A sessions. And I believe the participants still have many questions to ask, to address to the speaker, but we only have very limited time. So I would like ask the presenters, please kindly your email, then the participant could directly address the question to your email.
Sure. Yeah, I'll just provide my email in the chat so
Yeah,
that
the chat box. Yeah,
so that everybody can contact. Sure.
Yeah.
No problem. Okay.
Okay, thank you very much for all the speakers. Now we finally came to the end of these sessions. Again, thank you very much for the informative and insightful presentations from Bu Dr. Nur Hafila, Ibu Prisca, Pak Syahrul. And for that, let us give virtual clap or thumbs up for all the speakers. Click the reaction below. Okay, now, ladies and gentlemen, thank you very much for attending this joint class, and see you tomorrow. We still have one more sessions tomorrow, and I hope these sessions, this joint class will be beneficial for all. Thank you again. Assalamualaikum warahmatullahi wabarakatuh.
Assalamualaikum warahmatullahi wabarakatuh.
Thank you.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you once again, Ibu Dr. Rika Kurniati, SHMA, Ibu Dr. Nur Hafilah Musa, Bapak Syahrul Sajidin, SHMH, and Ibu Prisca Listiningrum, SHLLM. It is very interesting discussion. Thank you very much. Everyone, due to the limited time, my apologies, maybe we couldn't accommodate all of the questions here. So if you still have some questions or wondering about something, you can ask the speakers privately by email. The speakers already write their email address, so just save them, and maybe next time or right now, after this meeting, you can ask them directly. Well, before we end this joint class, let us take photos. So I'll request to all of the participants to turn on the camera so that we can get a good picture. Please. Our operator will take our photo snapshot. There are 9 screens. We already have 219 participants here, and some of them are in the YouTube. They view it from YouTube live streaming. But actually today's joint class attended by more than 300, I think, yeah? Okay, there are 9 screens. So you can say hi to the camera, or thumbs up is also welcome. Okay, wait a moment. Still on the 8th screen. Okay, nice. Thank you, everyone. I have some information for you all. Don't forget to fill in the attendance form, which has been sent in the chat room via Zoom or in YouTube channel. Don't forget, write your name, write your email address correctly, because if you make mistake in there, then it will be trouble to sending the A certificate to you. So, ladies and gentlemen, we've reached the end of this joint class. Me, myself, and all of the organizing committee, thank you for your very kind attention, very kind cooperation. And don't forget, we hope to see you again in the next final joint class tomorrow at the same time, 3:30 p.m. Stay healthy, stay positive, and be happy. Once again, thank you very much. Wassalamualaikum warahmatullahi wabarakatuh. See you.
Thank you, Dr. Nur Hafila.
Thank
who
you very
brings
much.
the discussion.
Thank you very much to all of you.
Yeah,
Thank you for
very
having me.
much for colleague from University Kebangsaan Malaysia.
Okay, ketemu lagi nanti
Yeah,
insyaAllah.
see you again tomorrow.
Okay,
And thank you, Mbak
Thank
Viva,
you.
Bu Prisca,
Bye.
Bu Dr.
See you
Nur
in the
Hafila,
future. See you tomorrow.
Bu Dr. Rika. Thank you.
Tanah airku tidak kulupakan, kan terkenal selama hidupku. Biarpun saya pergi jauh, tidak akan hilang dari kalbu. Tanahku yang ku cintai, engkau ku hargai.
Yang memerah darah, yang memutih tulang, kerinduan untuk Indonesia tempatku berpulang. Sejarah mengakar sejak saya lahir. Semangat yang tak akan lekang hingga akhir. Indonesia hidup bernafas dalam geram tubuhku. Meski ke tanah seberang ku habisi waktu, tetap raga ini mengantar mimpi Ibu Pertiwi. Junjung naba baik, tinggi, tinggi.
Walaupun banyak negeri ku jalani, yang masyhur permadi kata orang, tetapi kampung dan rumahku di sanalah ku rasa senang. Tanahku tak ku lupakan. Engkau